Healthcare is too expensive. Employers are offsetting costs onto their employees. Who will make health benefits affordable for hard-working Americans and their families?
You will! This is the Empowering Plans Podcast, a show dedicated to helping you once again emphasize the benefits in your benefit plan. Now prepare to learn,
Plan,
save,
and protect with the FIA Group.
Hello, everyone. Welcome to another edition of the Empowering Plans Podcast. I'm your host for today, Brady, Bizarro, and joining me is Corey Crigger, our Senior Provider Relations Attorney here at the FIA Group. Say hello, Corey.
Hello, Corey.
All right, off to a good start. And today is going to be an exciting in the weeds podcast. We had some Supreme Court cases. The last batch were decided last week, but Corey and I are here to talk about two of the biggest decisions from a very busy docket for the court this term, because they have a really big impact in our industry. And we're going to tackle two of them today in this podcast. We're going to talk about one case in which the Supreme Court blocked an opioid settlement with Purdue Pharma. Harrington is the name of the case. We'll put these in the description of the podcast so you can look them up. We'll also have these in writing, I'm sure, in our other blasts and emails. But the Harrington case is the first one we'll talk about in the opioid settlement. And then the second case, the Loper case, which effectively ended a legal precedent called Chevron deference, very important for our industry as well, and has huge implications for federal agencies and rulemaking. And so today we're going to kind of dive into both those cases, talk about what they were about, why they're important, and what we can expect as an industry moving forward in light of these cases. So yeah, let's launch into it. To start off with, we're going to look at the Harrington case. And so one of the big cases the Supreme Court released last week had to deal with a bankruptcy deal that the company Purdue Pharma had reached, something about $7 billion. I remember Purdue Pharma makes the OxyContin drug, and the owners of that company are the Sackler family. And essentially, and Corey will jump into this in a minute here, but you'll see that what the court decided is that this deal cannot be sustained. It has a big impact for our clients. It got tossed back to a lower court. And it sets up all kinds of questions for us to navigate and a lot of issues that are going to be playing out in the next couple of years. So Corey, why don't you give us sort of your take on what this case is about, background of it, and we can talk about the issues involved and what we think clients should know about it.
Yeah, absolutely, Brady. Thanks for teeing me up there. When this decision came out last week, I shot Brady an email because this is something that hits very close to home for me. And in order to understand what the Supreme Court has decided in the Harrington case, I think it's important a little bit to understand the background of what exactly Purdue Pharmacy did in terms of marketing and selling OxyContin and pushing OxyContin to prescribers. For those of you who don't know out there in podcast land, I was born and raised in Eastern Kentucky, right on the West Virginia border. And that area, there's actually a sign outside of my hometown that says heart of the $1 trillion coal field, because the economic driver of that area was the coal mining industry. So how does that relate to what we're talking about with Purdue Pharma and the Harrington case? In the 90s, when Purdue was bringing OxyContin to the market, wasn't a new drug at the time. It was just a pure form of codeine that removed the acetaminophen aspect of it. And 40 milligrams of OxyContin was the most concentrated version of an opioid that had been introduced into the market. And what Purdue Pharmacy did was they went to areas in which they thought that acceptance of this high dosage of painkiller would be the most effective from a sales perspective. And they tabbed the coal mining towns and a lot of other blue collar industries around the country as prime opportunity for marketing. And the marketing push that Purdue was going with, the line of reasoning that they were going down, was that it was less addictive. The only people who had actually become addicted to OxyContin were those who had a proclivity to be drug addicts, that by treating pain as the fifth vital sign, that was actually a doctor doing his due diligence. So your blood pressure, your vitals, the fifth vital sign being pain. Are you in pain right now? And then treating that. And what they did was that they focused a massive amount of resources into marketing OxyContin into my hometown and my area. And I could go for an hour on this, so I'm going to keep this very high level, but it is something that is very interesting, and I would be happy to answer any questions offline about it that anyone talks about. But they've targeted an audience, and within a decade, 81 million pain pills went into my hometown. Specifically, there's an article, and we'll put this link in the description as well with the case. There's an article from The Guardian in 2019 that profiled 2 pharmacies in my hometown. When I was in high school and throughout college, I worked at a competing pharmacy that I will not mention here, but I will go out of my way to say that we were not mentioned at all in this article because my head pharmacist and those who worked for him were very well aware of what was going on with this influx of opioids into the area. But this article highlights the fact that 30 million pills were distributed to 3 pharmacies within a 10-mile area, and the total population in this 10-mile area was less than 4,000 people. These scripts were being filled at an alarming rate. There were patients that were driving hundreds of miles from the kind of northeastern panhandle of West Virginia that borders around Pittsburgh. They were driving to the southwestern corner of West Virginia, where I kind of grew up and where I worked, to get their pain pills filled. And the reason that they were doing this were that there were several doctors in the areas running what has been known as pill mills, where I remember going to high school and seeing lines around a city block of people standing to waiting to be seen by a physician. And this physician would instantly write a script for whatever painkiller that you wanted. And then you would walk down the street to one of these pharmacies mentioned in the article, and you would instantly get a script with no questions asked and no background checks. One of the head pharmacists at one of the named pharmacies passed away while criminal charges were being brought up on him. Another faced several charges. What Purdue Pharmacy did to my area was create an entire generation of drug addicts, and that rippled down to my classmates. The first time I saw someone do illegal drugs, I was 12 years old in 7th grade, and I saw a classmate snort a pain pill at 12 years old. And this was all because of the access that was being made to these high, powerful narcotics within the area. It has completely devastated the economy, among other regulation and within the coal industry. You had hurt and aching bodies that were being prescribed painkillers, and then you had the downturn in the socioeconomic impact of the coal industries throughout multiple presidential administrations. And essentially what has happened to my hometown is that it's become a ghost town that is almost unrecognizable. So that's a little bit of background on why I'm so passionate about it. If you jump into what Harrington actually did, was the Sackler family, once the heat started getting turned up, that they realized that some of the marketing techniques that they were employing, the chickens were going to come home to roost on that. There was no valid evidence that OxyContin was less addictive. They were misusing data or overly citing obscure doctors' opinions from the 80s to push this marketing effort. So when the DOJ started looking into the Sackler family, the quote from one of the high-ranking members of the Sackler family was that they started a milking out process in which the revenues from the Sackler family went from about 15% of the total revenue generated by Purdue Pharmacy to over 70% of the profits generated by Purdue Pharmacy was being diverted to the Sackler family. Ultimately, this led to Purdue Pharmacy declaring bankruptcy, and what the Sackler family offered was to back about $6 billion worth of cash to aid in the bankruptcy proceedings among all creditors. But the trade-off for that would be that they would not be individually liable, that they would have immunity for any current and future actions being taken against them. And the Supreme Court ultimately said that we are not going to allow the Sackler family to enter into this type of an agreement with the bankruptcy court because you are releasing a party that is not directly involved. So the victims of the marketing scheme that Purdue Pharmacy went on, the actual people who are addicts, that class of people are not a party to the agreement between the Sacklers and the bankruptcy court. So the Supreme Court ultimately said that we are not going to approve this bankruptcy structure because we're not going to let the Sackler family be able to be released of all liability through the bankruptcy proceeding without parties that are there. Now, there's a lot of implications for that, but Brady, I've talked for a lot there. Any questions or anything you would like to add to that?
I think, Corey, it's worth just pausing to just laser focus in on what you described here, because it's really insidious and frankly pure evil. I mean, honestly, what the Sackler family has been alleged to have done here in this case, in fact, if you read the first 2 paragraphs of the Supreme Court decision, the syllabus is what they call it here, they describe the scheme that Corey just laid out for you here, where they initiated the milking program, right? Transferring money from Purdue to their own pockets, $11 billion over a decade on purpose, knowing that they'd probably end up being sued, right, for what they've done here. And yeah, I mean, this is a case where the Supreme Court cited this example that they were trying to follow through with, and the bankruptcy plan could have been used by other institutions and corporations to shield themselves as well. And so for one, I think many analysts feel the same way. I'm glad that the court found that the bankruptcy process can't be abused in this way, where you have, in this case, again, wealthy individuals who, and the evidence was pretty clearly showing that they knew what they were doing here and marketing these drugs to make themselves insanely wealthy, and then to try and shield themselves from the legal liability from this is just absolutely abhorrent. And I think what this means going forward is that hopefully other players in this space and other spaces in the healthcare space, right, will think twice before implementing something like this, a plan to, addict people to drugs or whatever it may be. One thing I wanted to add, Corey, maybe see if you have thoughts on this as well, is everyone knows somebody most likely who was affected. I myself, one of my older cousins, unfortunately passed from an overdose on opioids a couple of years ago, which is awful for his family and for mine, obviously. But many people have similar stories out there they can relate to, people impacted by this. But there are other settlements out there involving some of the pharmacies, right? CVS, a couple others have been named as well, that have settled with some of these families. So oftentimes I mention that because you hear there's a lot of pressure, right, to accept these settlements because the people need this money, the communities need this money involved. And so I guess it's worth making the point that even the Sackler family was, of course, saying, oh, look, hey, you got to settle with us and give us liability, and we'll give you, access to all this money that you desperately need. These communities and these people can get some money from other sources for now, from some of these other settlements. And so I think, thank God for that, in my view, because otherwise, I think the Sacklers are counting on the desperation and feeding off the desperation of people to just sort of force these settlements down people's throats. And it looks like that's not going to happen. Last thing I'll say before getting back over to you, Corey, is if you Google, you'll find a lot of these cases here where when the bankruptcy process was getting underway, different interested parties could file a claim of proof of loss, or a proof of claim form is what it's called. And in the healthcare space, you'll see a lot of money, billions of dollars have been spent by self-funded plans, right, treating opioid use disorder. And I found one, and I just want to mention briefly here, from United Healthcare, where they had filed a claim to the bankruptcy court saying that they suffered a loss as an insurer of $9.8 billion for damages over a course of 4 to 5 years on behalf of their self-insured plans and their fully insured plans. And one of the things that we've been talking about for years before this case came down was the potential subrogation opportunity that could arise from some of these settlements, because it's not just United, obviously. Every single self-funded plan out there probably has somebody on it who was impacted by this disaster, and the plan had almost certainly paid out or has paid out money to treat opioid use disorder, and there could still be an opportunity for some of that money to get recouped, depending on whatever happens to the bankruptcy court now and the filing going forward. There'll be a new settlement, right, Corey? So there's an opportunity perhaps for plans and people to get relief out there going forward.
Yeah, absolutely. There's a lot of good points there. That the big case that was settled in West Virginia with the companies that delivered the drugs to the pharmacy, right? The three companies were responsible for delivering 95% of the opioids into the pharmacy via their distribution. But this is a situation where everyone's pointing the finger at each other, right? The distributors are saying, well, we just filled order by pharmacists. And the pharmacists are saying, well, we just filled scripts written by doctors. And the doctors are saying, well, Purdue Pharmacy told me that I should prescribe first because this was a less addictive substance. So everyone is trying to pass the buck. There are settlements out there. There are relief for these families. I do think it's important to point out what exactly the money fronted by the Sacklers would equated to in the pockets of the victims. It was a structured settlement arrangement where I believe that the low end you would get $4,000, and at the high end it was capped around $50,000 per family who had a loss or someone who passed away for drug overdose. And the Sacklers structured it where if you were above the minimum, they could pay you out over 10 years. So when you talk about a family that milked out, again, those are their words, revenues to the tune of $11 billion, and then reinvested that in separate business entities or the market or whatever they did with that money, and then capitalized on it. And you zoom into what families who don't have loved ones anymore, what they are actually getting, it is wetting the beak is an understatement, and I can't express that enough. And the last thing I'll say on this, and then we'll kind of move to a little bit broader, no pun intended, topic with the Loper Bright case. is that the extent that Purdue Pharmacy and the Sackler family by extension went to get some of these marketing measures approved is quite interesting. I would behoove everyone to read the opinion and news articles related around this, but there were high-ranking officials within the FDA approving the marketing strategy. There were whistleblowers that came and talked about the marketing strategy that was being put forth by Purdue Pharmacy. The FDA ultimately said, no, they can market this way. They can market the extended release. They can market less addictive. They can market all these ways that they're doing. It's absolutely fine. And several high-ranking members of the FDA, after that was approved, took consulting jobs or seats at the board of Purdue Pharmacy. So when you have skepticism in the market about quote unquote big pharma, the reach that they have, whether or not a drug is being pushed or whether or not a drug is being approved, it's these types of scenarios that lead to questions, that lead to conspiracies, that lead to people questioning who is actually benefiting from a new drug coming to market. I don't believe that every pharmacy company acts this way. I think that would be a detriment, disrespectful to other companies, but I do think that when you see people who are wary of new drugs, new trials, being told what or what not to do, what or what not to take or inject in their body, like this example is the reason why people are wary. So I'll leave it at that. And then we will transition. Again, I'm happy to field any questions on this topic. It is very, very topic close and near and dear to me. But the other big Supreme Court case, and Brady, I think we could have possibly thrown darts at a dartboard to pick an impactful Supreme Court case from this term. But the one that we're getting all the questions on right now is what in the world do we do now that Chevron deference has been overturned via the Loper case? And just for a little bit of background and a little bit of setup, when Congress passes a law, they can delegate some authority to carry that law out to the various administrative agencies that are in DC, right? Pick your alphabet soup agency. They can defer this authority and delegate authority to carry out what they've passed in statutes. And in 1984, a landmark Supreme Court decision was made, the Chevron case decided by the Supreme Court, basically said that Congress can delegate, but if there is an ambiguous interpretation of a statute that delegates authority to the agency, then there is deference given to the interpretation that the agency has in interpreting ambiguous statutes. So that means that the agency was a higher bar to kind of overcome agency regulation or have agency regulation struck down in a court when it came to unambiguous terms, because the Supreme Court decided that the experts at the EPA or at the FDA or at HHS, like these agencies were the experts in the field. Therefore, they are going to be given deference when they interpret ambiguous terms of the statute. So that leads us up to some fishermen in the Northeast, Brady, and maybe you could take it over from here and walk us to how we got here today.
Yeah, thanks, Corey. That's exactly a perfect setup for this. I'll just add before I give some of the brief facts of this particular case, but I think, Corey, one of the insights, I think people should have on this case is in your setup of Chevron in general. It sounds, I think, pretty reasonable to most people what you just described here. Agencies have experts that work for them, doctors, pharmacists, maybe even lawyers, or God forbid, usually scientists, let's be honest, right, that can weigh in on an agency to decide what makes sense for implementing a certain law. What's happened over time, though, is that Congress has either, and these are my opinions, has gotten a bit lazy, right, in legislating. Maybe they purposely draft ambiguous laws because they don't really want to bother to fill in all the gaps. Let the agencies do that, right? That's one thing. Or more recently, I would argue, Congress just can't pass many laws in general. So you have agencies stepping in, right, to sort of fill the void here and just acting where Congress can't act, and in some cases clearly beyond the scope of their mandate. But now with throwing out the whole baby with the bathwater, we'll see what kind of situation we're left with. Before that, quickly here, on this case, Loper Bright Enterprises versus Raimondo, and Raimondo is Gina Raimondo, the Secretary of Commerce at the present moment. The Secretary of Commerce has the authority to, quote, implement a comprehensive fishery management program. That was within the statute here. That's directing the Commerce Department to implement a fishery management program. That's pretty much all it says. And I would argue that that was done by design. Congress doesn't know how to implement this kind of program, so let the agency figure out how to do that. And one of the things that the agency did in carrying out or developing a fishery management program was to require observers to be carried on board ships, fishing vessels in particular here, to collect data, right, to make sure that other laws are being followed with respect to conservation and overfishing and things that sound pretty reasonable. What was added here, though, and why this became a case is because the National Management of Fisheries, the service there under Commerce issued a regulation requiring each vessel to pay for the observers, and that was about $710 per day. And so that was not listed in the statute, the ability to levy a $710 per day fee effectively, right, per observer. And so that's why this case was brought, because the argument was that that was beyond the scope of the law, that was outside the bounds of Commerce's ability to act. Of course, the response from the agency was that, well, look, obviously, these people cost money to employ, these observers, and surely, it makes sense to have the vessels themselves pay. But actually here in the Northeast, not every fishing vessel is owned by a giant company that can afford these kinds of costs. And so there were some smaller businesses that were very adversely affected by this fee, and it was really detrimental to them operating and staying in business. And so that was the sort of genesis for this case here. And I think it kind of describes, I think, pretty well why the court reached the decision it did, because the court said that if Congress intended, an expenditure of funds or a fee in this case, or payment required, it would have put that in the statute. That's a pretty significant burden for the agency just to decide on its own. But really what observers of this case have said is that this is an opportunity the court had, and they took it to kill what many view as a really unworkable doctrine, the Chevron doctrine. It sounds reasonable on its face, but really it has led to, in some cases, agency overreach. And by the way, that's both sides of the aisle have been accused of this. Republicans and Democratic administrations have been accused of using their agencies, respectively, to overinterpret a statute or read into it things that weren't actually there. But really, this is going to cause a lot of chaos, really, for the entire federal government. It's going to change the way that agencies act across the board. And I'll let Corey jump in a minute here and sort of let me know what he thinks. But what I think is going to happen here is you're going to see a rush to the courthouse across the board, challenging every agency rule that interest groups don't like, especially those that already were seen as precarious. So I'm thinking particularly here, in our case in the healthcare space, all the agency rules that relate to the No Surprises Act, things that have already been found by some courts to have gone beyond the scope of the legislation, there you're going to see even more challenges to that. I think the FDA, we just had a case we talked about in a different format on the Supreme Court upholding temporarily, at least, the ability to access medication abortion. That was a case decided due to a lack of standing or a procedural issue. But I think now the challenge to FDA's authority to allow mifepristone, the medication involved here, I think that authority itself will be challenged, the FDA's authority. Now that you have Chevron deference being tossed out the window, you're going to see that case, I think, refiled by somebody who does have standing. And so it really upends a whole host of regulations that we count on for understanding how to really run the healthcare industry. So Corey, what's your take on what's going to happen in a post-Chevron world?
Thanks, Brady. I think that, one, I'll just say on the outset, I think one of the not talked about enough aspects of this is that Congress is an extension of the will of the citizenry, of the people. And I think that this will make Congress more accountable, right? Your congressman must draft and sponsor and pass legislation with specificity, and they can't just offload this to unelected bureaucrats that live and have been in these agencies for 30 or 40 years to carry out the will of Congress. So that's one thing that I think you could go and talk about. The other aspect of it that I think is super interesting is just the unknown, right? The Supreme Court went out of its way to say that they're not overturning any decision that was decided on the basis of Chevron, that this is kind of a new bright line and a new starting point, and it will be new challenges going forth. But what aspect of the healthcare industry isn't at least touched in some way by massive federal regulation, whether it be from the PBM space, whether it be from administering the health plan space? It's so far reaching. And now what is going to happen is that when a challenge of a regulation from an agency comes before a court, the judge is going to use, and I believe the exact quote was, normal means of statutory interpretation to determine whether or not an agency overstepped its bounds with any specific given regulation. So I think, Brady, you hit the nail on the head when you said Congress has gotten lazy. It's going to require Congress to specifically and unambiguously delegate authority to these agencies. And it's going to keep the agencies reined in to acting within their prescribed authority. And when agencies overstep these bounds, is going to help the challengers of these regulations to have a more fair fight for when a judge is going to interpret the statute and say, hey, no, this is what congressional intent was with this law. We're not going to give deference to non-judicial parties in interpreting statutes because the courts are supposed to be, and they went back to quote John Marshall on this, that they interpret the law. That is the proper function of the judiciary branch. So it's going to be a return to some judicial authority and statutory interpretation here. But honestly, it's one of those questions, Brady, we get it, and then you get the classic law school answer of it depends, it depends, it depends. What are they challenging? How are they challenging it? Does the agency have delegated unambiguous delegation from Congress? If so, it's not going to change. It's those aspects where agencies were taking, lack of a better term, they were judiciously interpreting ambiguous terms of a statute to enact what they wanted to enact. So yeah, who knows what's going to happen next, but it's going to be a wild ride, and it's going to make the webinars, the blog post, the podcast, I think we're going to have a lot of content over the next year.
Yeah, one of the things for sure is I think for lawyers, especially, generally speaking, you're going to have a lot to do in the years to come because this is going to cause a lot of earthquakes. I want to just add a couple of quick things based on what you said, though, Corey, because I agree. I think you and I are aligned here that we think it'd be good if Congress did their jobs better, frankly, in drafting legislation to make things clear about what their intent actually is. The problem I see, though, is I'm not so sure that's what's actually going to happen. If you look at Congress these days, they spend seemingly every waking moment fundraising, insane amounts of money you have to raise now. We just had a political race in New York's district for a House seat, something like $24 million was spent. So, I mean, how much time do congressmen and women have, are they going to make to write laws? I hope they spend more because that's what's needed here. One of the things I've heard too, and people say, well, Congress members themselves also aren't the experts. That's why they should be deferring to agencies. I would argue that they should be using congressional hearings better instead of investigating everyone and everything. If you have a hearing, you bring the experts into that hearing and then collect the data from the experts at the hearing, and that helps you inform the legislative process. So there are ways that Congress can, hopefully we're not being naive here, but we're relying on a picturesque view of what Congress should be, right? They should be legislating effectively, appropriately, clearly. Unfortunately, the reality is that's not often the case. And again, at this point, we're lucky to get legislation moved at all. We've been talking about PBM reform for it feels like 6 years, and there hasn't been a bill that's been actually passed. So I think we're not out of the water yet with respect to how things play out and whether we'll actually see more transparent and more clearly written statutes. Hopefully going forward, this will sort of force Congress to change and, like you said, hold them more accountable in the future and hold us more accountable because we're going to have a lot more work to do in the coming weeks and months, as Corey alluded to. And we're happy to answer further questions you guys have. I know there'll be more of them. I will have much more to say both on these two cases and the other very, very important cases we discussed on our ICE webinar just recently related to abortion services and EMTALA, emergency procedures and the like. And we're going to be watching what challenges are brought in the near future to existing agency rules. There was one we covered recently with the EEOC and the Pregnant Workers Fairness Act. That's been challenged, and now this Chevron decision will throw that up in the air as well. But for all things and all questions related to our industry, make sure you're tuning into our podcast, our webinar, and reaching out to us in general with your questions, and we'll be happy to answer them. I think for now, though, we did a pretty good job of covering two of the most important cases. I know Corey and I can talk about them for 20 more minutes, but for the sake of this podcast, I think it's a good point to wrap it up here. So I want to thank our audience, our listeners for tuning in as you so faithfully do. On behalf of myself, Corey Crigger, and our man, Pat, the producer Santos.
Shout out, Pat.
Thanks again, and we'll see you next time.